It's Thursday. I can't believe it. It's November 20th, and we need to talk all things Brian Walshe. We're going to take a look at what happened in court as jury selection was getting underway. They almost have a jury in this case, and it looks like it is just speeding towards trial. But I got a ton of questions about him taking a plea. Like, why are we taking a plea as like a jury's ready to walk in the door? We're going to watch that together. We're going to talk about the plea. We're going to do all the things. Brian Walshe is charged with killing his wife, Ana Walshe. She went missing in early January 2023. Her body was never recovered. He was also charged with lying and misleading police and with dismembering and disposing of a body. This is the first case we are looking at that is a no body homicide case. And what I mean by that is there was no autopsy. There's not going to be a coroner. You're going to hear information about her going missing, people looking for her, but you are not going to hear information of manner of death, cause of death, those sorts of things. Why? Well, because there's no body. The judge ruled Monday on several issues regarding what evidence and testimony the jury can hear, including statements from Ana's friend about a fight the couple had just days before she was killed. Brian Walshe's online searches are also under scrutiny, including 10 ways to dispose of a dead body if you really need to, and searches related to pornography involving a cheating wife. Wait, where's the one that's how long before a body starts to smell? That's in there too. Also, the fact that we got to a Google search of 10 ways to dispose of a dead body if you really need to is wild to me. In addition to that, we also have the circumstance that prosecutors are going to try to prove that Brian Walshe was aware that his wife was getting ready to leave him or potentially leaving him, and she was also having an affair with somebody else, and he had been searching that person up. I think the defense is going to be arguing that he did not know she was having an affair. But the dispose of a body if you really need to, there were lots of searches related to that, but those searches were done on their child's iPad. Yeah. These are not searches that their child is doing on the iPad. So they are proceeding to a change of plea right before the jury comes in. All the motions in limine happened on the 17th. He comes in the morning of the 18th. They've got the jury outside waiting to come in for jury selection. And he's like, excuse me, I'm going to change my plea. They were going in for jury selection.
Mr. Walshe, can you please stand?
Lovely, not a plea deal.
I wish to offer a change of plea on docket number 2382CR91002, which charges you with intimidation of a witness, juror, police, or court official, and 003, disinterment of a body. Do you wish to offer a change of plea from not guilty to guilty?
So those are the two charges. He has 3 total charges. Count 1 is the murder, then the lying, misleading police, and then what they call disinterment of a body, the disposing of a body. He is changing his plea.
I do. Could you raise your right hand, please? Do you solemnly swear to make true answers to such questions that should be put forth to you by the court, so help you God?
I do.
Thank you.
They are doing a full colloquy before the plea is taken.
Are you married?
Yes.
Well,
Do you have any children?
Yes.
And
I think there's questions about the are you married part.
as I understand it then, sir, you're pleading guilty to these 2 indictments because you wish to plead guilty because you are guilty. Is that correct?
That is correct.
Counsel, do you know, defense counsel first, do you know of any reason why I should not accept your client's guilty plea?
You do not, Judge.
Same question to the Commonwealth.
Your Honor, I'll be brief, but we had spoke. This is a non-negotiated plea with the Commonwealth, and we had some objections to it. But my concern was where the defendant equivocates on the factual basis that the Commonwealth read in, that is one reason you should not take it. And the second is this count 3 revolves around improper disposal of Ms. Walshe's remains. And the defendant, when asked his marriage status, said that he was married. And consequently, Your Honor, then that is not an accurate relaying of his current status to the court and could be invalidating.
Interesting.
So I believe he has to be asked that question again. And I believe that if he continues to say he's married, that he's negating facts of count 3.
All right.
So the prosecution just said, hey, Your Honor, when you asked the defendant his marital status, he said he is married. Technically, he is pleading guilty to count 3, which is disposing of Ana Walshe's body, which now admits not that Ana Walshe is missing, but that Ana Walshe is deceased and that he is the one who disposed of her body. So he can't say that he is married. He can say that he is widowed. He can say that he did not cause her to die, but she did in fact die. But he cannot say that he is married. And so the prosecution is like, hey, that seems to be misleading. If he's agreeing to disposing of her body, he's necessarily agreeing that she is deceased. He's not admitting that he murdered her, but he is agreeing that she is deceased and he disposed of her body improperly and unlawfully. So the DA is asking to get back to that. I was wondering if he was going to get back to that because it was odd when the court said, are you married? And he's like, yeah. Sir, you're sitting here to plead that you got rid of her body. What do you mean, yeah? But the attorneys have been very precise in what we've seen today. Both the prosecution and the defense have been quite precise in their language. I hope this is a sign of things to come.
I'll give defense counsel an opportunity to speak with your client.
Your Honor, I apologize. I couldn't exactly hear what Mr. Connor's caveat was.
In response to one of the early questions I asked of the defendant, I asked him if he was married, and he said yes, he was. And the Commonwealth was raising the point that if that were true, that it might negate proof of the disinterment, which requires a human body or remains.
Right.
Do you want to speak to your client about that?
A moment, Your Honor.
And the court's going to colloquy again.
Mr. Walshe, earlier today I asked you whether you were married, and you answered yes, you were married. Do you remember that?
Yes, Your Honor.
And is it correct that you were married to Ana Walshe for a period of time?
Yes, Your Honor.
And that under the law, death extinguishes marriage. It may not religiously or otherwise, spiritually, but under the law, when someone dies or when someone is dead, you can no longer be married to them. Do you understand that?
Yes.
Yes, Your Honor.
And so are you married today?
Your Honor, if I may, insofar as previous discussions, for purposes of a successful plea colloquy and meeting the elements of the crime, he is acquiescing to the fact that lawfully he is not married today.
All right. You heard what your lawyer just said? Agree with what your lawyer just said?
Yes, Your Honor, I agree.
All right. Anything else that we need to cover?
No, Your Honor.
All right.
He is
to the extent that the Commonwealth is objecting to.
He is acquiescing for the purpose of a successful plea colloquy that he is no longer married. Okay.
The taking of the plea on other grounds that is overruled. My job here is to make sure that I have a valid plea. And that means that the defendant is pleading guilty to the elements that the Commonwealth would have to prove beyond a reasonable doubt. And I have inquired sufficiently to assure myself that he has admitted to each of the elements of the 2 offenses of indictment 02 and 03. You understand, Mr. Walshe, that at the time that we do get to sentencing, that by law, I'm not bound to any recommendation that's made by the prosecution or your lawyers. You understand that?
Yes, Your Honor.
And that I may impose any sentence.
The court is straight up like, I can do what I want. He's changing his plea. That's it. Full change of plea. So the court's like, I can do what I want. I can sentence you to what I want. I am not bound by anything. You have no agreements. I can sentence you to the max. I cannot sentence you to the max. I get to choose. It's up to the court. He is pleading open to the court.
It's permitted by law up to the maximum allowable sentence.
Yes, Your Honor.
Having considered Mr. Walsh's criminal history, the government's proffered evidence, I will later consider the victim's statements to the court for matters for sentencing. I find that Mr. Walshe has met the requirements to tender a plea to counts 2 and to counts 3. I make the following findings. I find that the defendant is not presently under the influence of drugs or alcohol, and that he hasn't reported that he's not presently suffering from any mental illness or condition, and that he's not presently taking any medications. I find that the defendant understands the nature of the charges and the consequences of his pleading guilty. I find that the defendant's change of plea to guilty with respect to each of the two indictments, 02 and 03, is made knowingly, willingly, intelligently, and voluntarily, and with the full knowledge of its consequences. I find that the defendant's change of plea on these two indictments to guilty is made upon and with the advice of competent counsel. And I find there's a factual basis in the evidence as has been summarized by the prosecution and limited by defense counsel on behalf of the defendant for each of the two indictments to which the defendant now pleads guilty. Accordingly, I accept Mr. Walsh's plea of guilty as to indictments 002 and 003.
And those guilty pleas have been accepted. Honored, you know I love a sponsor that makes things easy, and HungryRoot does exactly that. I love that HungryRoot is delivered right to your door with meals or groceries or any combination in between, depending on what your needs are in any given week. Plus, it's really easy to pause a week if you need it. It's perfect for this busy time of year, so whether you want to be able to put together dinner or lunch or breakfast, or you just need grab and go, HungryRoot has you covered. And unlike other things you may have tried, HungryRoot has over 50,000 recipes to choose from every week. Plus, you can sort by how long they take to put together. I absolutely love the garlic parm bruschetta with creamy pasta and chicken, and I always add my favorite vanilla protein pancakes to every order. Plus, the sour crunchy gummy rings are a 10 out of 10. So if you need help having meals picked and planned, groceries delivered, and you need the flexibility to choose, HungryRoot has you covered, and I've got you covered with a discount. So take advantage of this exclusive offer, and for a limited time, get 40% off your first box plus a free item in every box for life. Go to hungryroot.com/Lawnerd and use code Lawnerd. That's hungryroot.com/Lawnerd and use code Lawnerd to get 40% off your first box and a free item of your choice in every box. Look, we all need to eat. We might as well just make it easy. And now let's get back to today's show.
Now let me give you a brief description of this case. As I mentioned, this is the trial of a criminal case. The Commonwealth alleges that on December 30th, 2022, Ana Walshe returned home to Cohasset from her job in Washington, D.C. to be with her husband, the defendant, Brian Walshe, and their children to celebrate the new year. At that time, Ana Walshe lived and worked in Washington, D.C., and would return to the family home in Cohasset, where her husband and 3 small children continued to reside. The Commonwealth alleges on January 4th, 2023, Ana's employer called police to report that she was missing. Cohasset police went to the Walshe home, where the defendant reported that Ana was missing and alleged that she had left the house early the morning on January 1st and that he had not heard from her since then. Days later, police searched a dumpster outside the defendant's mother's Swampscott apartment and found clothing that belonged to Ana Walshe, Ana Walshe's COVID vaccination card, towels with red-brown stains, a hatchet, and a hacksaw. The defendant is charged with murdering Ana Walshe. The defendant denies these allegations, is presumed innocent, and has pleaded not guilty. Let me talk a little bit about the trial for the schedule. The schedule for the trial, try it that way. Today, as you know, is Tuesday, November the 18th. We plan to select the jury before Thanksgiving, and we will start the trial itself on Monday, December the 1st, 2025. The lawyers estimate that it will take between 3 to 4 weeks to try this case and to present all the evidence. The jury will then meet to discuss and consider the evidence and issues in the case, and we call that deliberation, to reach a decision, which we call a verdict. There is no set time for a jury to decide a case. The jury takes as much time as it needs to unanimously decide the case.
Brian Walshe is going to trial. I thought there would be more delays, especially because former trooper Michael Proctor is connected to this case. This is a Norfolk DA homicide case. So there are a lot of familiar players, but this case was investigated after the Karen Reed case, but not that much after. This happened right over New Year's 2022 going into 2023. Prosecutors accused Brian Walshe of murdering his wife, Ana Walshe, dismembering and disposing of her body, which was never recovered. Today, we watched the court hearing where they were coming in for jury selection, and the defendant decided to plea to the court. This was not a plea agreement with the prosecutions. This was the defendant saying, hey, as to count 2 and 3, I'm going to take a plea. I plea open to the court, sentence me to what you want. There's no agreement. And I'm only going to trial on count 1, the murder charge. Yes, defendants can choose to do that. They can plea open to the court at any time. We're going to talk about the strategy of that in just a moment. But it is not going to substantially limit prosecutors, from my perspective, in presenting some of the most damning evidence that we've heard about in this case, including Google searches. I also think it's pretty telling that it was her boss that first reported her missing and not her spouse. And then police were like, hey, it seems that your spouse might be missing. He's like, oh yeah, about that. She went to Logan and then we never heard from her again. Well, the thing about airports are what? They have a whole lot of checkpoints. They have a lot of video. There's a lot of information in an airport. With all of the information that the defense got regarding Proctor's phone, and they were fighting about the Proctor phone right up until a week or two ago, and Brian Walshe had originally been set to go to trial and then delayed because he went out to have a competency evaluation after he was attacked in custody. And all of that in this case is still going forward to trial. So we are going to see what happens from here. But yes, after pleading on 2 of the 3 counts, he can still go to trial on just the murder count. I do not think it will substantially limit the evidence that's going to come in, because a lot of evidence will be shown as to consciousness of guilt, including things like lying to law enforcement, like disposing of a body, like the Google searches regarding disposing of a body. A lot of those things will come into evidence to show consciousness of guilt, in addition to proving those counts that now no longer need to be proven. What is the benefit to changing his plea? That is the number one question you guys have. Why change the plea? And of course, we're not in the mind of the defendant. We're not his defense attorneys, so we can only speculate, and that's what we're going to do. I've had a number of cases where defendants have chosen to change their plea, either to keep evidence about that count out, or so they can say, if they testify, look, I'm only fighting on the one thing I didn't do. I admitted all those things, and I'm not admitting this because I didn't do this. So it can set up a defendant to testify, which may very well be the case here, especially in a no-body case. If the defendant here is going to argue something along the lines of, something happened to Ana Walshe, I didn't kill her, something happened to her, and then I freaked out and we had been fighting and I thought I would get blamed, so I Google searched all this stuff and decided if I just got rid of her body, it would be better. And then he admits to the jury, look, I got rid of her. I lied to police. I was scared, but I didn't kill her. There may be some juries that are like, well, we don't know how she died. Maybe she fell down the stairs. Who knows? But we don't know. And then he freaked out. Okay, maybe. And that strategy is not uncommon in a no-body case, because there's no coroner to come in and say, no, this is what happened. The only way that strategy works is if he testifies. It is not a bad strategy. I freaked out because I knew what they were all going to say. And I knew that they were going to all look at me. And so I didn't know what to do. And so I didn't want my kids to know, and I was acting out of stress and blah, 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 blah. If that's his strategy, he has to testify. And if he testifies, he can say, yes, I lied to police. Yes, I got rid of her body. Yes, I did all those things. Those things I did. And I took responsibility for them. This is the thing I didn't do. It is a strategy to fight on count 1, in my opinion. I do not think this is a case where it will limit the evidence. Sometimes you have cases where it limits the evidence. Here, the evidence that would go to lying to police and the evidence that would go to disposing of the body improperly is also going to go to consciousness of guilt. Lying to the police also can be argued as consciousness of guilt. So that is still going to come in, but it gives him the opportunity to say, but I didn't kill her. And that is a solid strategy. And if they give lesser includeds, it might also move him out of the first degree murder into like a second degree murder or a manslaughter. Like we were arguing and she tripped and fell or whatever it is. I didn't mean to kill her, but she died. And then it reduces it from an intentional volitional first degree murder, because it's my understanding that all the Google searches are about things after the fact. So if that strategy works, he might get himself out of the life without parole category into a parolable offense to someday get out of prison. And the 2 counts that he pled to don't knock him out of the possibility of getting out sometime in the future. So this is a strategic play, but I think this strategy only works if he testifies. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.